Imagine a government where the people making the laws could um, simply fire the judges who strike those laws down.
Oh, wow. Yeah, that would be, I mean, that's terrifying.
Right. Or, where a local politician could just pick up the phone and transfer a magistrate who is about to rule against them in some land dispute.
Yeah, that sounds like a very fast track to a complete dictatorship.
Exactly. A system where rights are just like suggestions and power goes completely unchecked.
It would be an absolute collapse of the rule of law. And yet, avoiding that collapse doesn't just happen by accident.
Yeah.
It requires this incredibly deliberate, almost paranoid level of structural engineering.
And that engineering is exactly what we are dissecting today. So welcome to this deep dive. I am looking right at you. Yes, you, the dedicated learner, the relentless law student out there.
Yes, specifically, if you are an Osmania University LLB student gearing up to tackle Unit 2 of Constitutional Law 2, well, consider this your ultimate study companion.
We are looking at the invisible fortress the Indian Constitution built to protect its justice system.
We're basically going to decode the very DNA of the Indian judiciary. Because it's not just a hierarchy. It is a multi-tiered, tightly woven constitutional ecosystem.
It's designed to balance immense power with necessary restraint. And we have our study materials laid right out on the table here.
We do. We're pulling directly from the academic notes on Constitutional Law 2, the raw text of the Constitution of India, the bare act itself, and a stack of supplementary legal materials like that s.pdf file we have.
Yeah, and the mission for this deep dive is to completely conquer this specific unit. We're going to break down the judiciary from the absolute apex, the Supreme Court, down to the high courts and the subordinate judiciary.
And then we'll wrap it all up with the philosophical core of the entire system, right?
Yeah.
Judicial independence and that incredibly intense debate over judicial accountability.
It's a fascinating journey. You really cannot truly understand how, say, a simple contract dispute in a local district court functions without understanding the constitutional umbrella that protects the magistrate sitting in that very courtroom.
Right, because the local connects directly to the national.
Exactly. And joining me to navigate this massive architecture is our resident legal mind. Think of them as your virtual law professor for the duration of this deep dive.
I am ready. We're going to translate these incredibly dense constitutional articles into clear, memorable principles.
Awesome. We have a ton of ground to cover, so we really need to start at the absolute top, the apex.
The Supreme Court of India?
Yep. The logical place to begin, the ultimate guardian of the Constitution.
So if we open Part VI, Chapter 4 of the Constitution, specifically starting with Article 124, we see the establishment of this monumental institution.
And it doesn't just outline a court right, it creates a constitutional titan. Let's start with the sheer size and composition.
Okay, so Article 124 establishes that the court comprises the Chief Justice of India and up to 33 other judges.
Wait, so that gives us a maximum sanction strength of 34.
Exactly. 34 the highest judicial minds in the country.
When you think about a nation of, over 1 billion people, 34 judges feels like an incredibly small elite club handling the legal finality for an entire subcontinent.
It really is. It's a massive responsibility concentrated in very few hands. And, the journey to get to one of those 34 seats is rigorous.
I can imagine. So they are appointed by the president of India, right?
Yes, appointed by the president. And once appointed, they hold this prestigious office until they attain the age of 65 years.
Okay, 65. That specific age limit is crucial to highlight now, right? Because as we move down the judicial hierarchy to the high courts later, that retirement age is going to drop.
Very true. Examiners absolutely love testing that specific numerical distinction.
So, great flag for anyone taking notes out there. Supreme Court equals 65 years.
Yeah.
Now, regarding the physical location of this powerhouse, Article 130 specifies that the Supreme Court sits in Delhi.
Right.
But the text doesn't paint Delhi as an absolute inescapable prison for the court, does it? There's a caveat built in.
Yeah, there's a really vital piece of flexibility within Article 130. It clearly states that the court sits in Delhi or in such other places as the Chief Justice of India may, with the approval of the president from time to time, appoint.
Okay, so while New Delhi is the permanent constitutional seat, the framers intentionally left the door open for the court to potentially sit elsewhere.
Exactly. Perhaps in the south or the northeast, if the circumstances demanded it to increase accessibility. But it requires a dual lock.
A dual lock.
Yeah. Both the Chief Justice of India and the president must agree to move or establish a bench elsewhere.
It's like having a permanent fortified headquarters, but, keeping a mobile command center option in your back pocket just in case the geography of justice requires it.
That's a great way to put it. Now, before any of these 34 judges even hear their first constitutional challenge, they have to take an oath.
Right. The language of this oath is found in the third schedule and referenced in Article 124, Subclause 6. They swear to perform their duties and uphold the Constitution without fear or favor, affection, or ill will.
And those specific words, without fear or favor, they are not just ceremonial poetry. They are the absolute legal bedrock of judicial neutrality.
How so?
Well, when a judge stands and takes that oath, they are publicly and legally severing their ties to any prior political affiliations.
Personal biases, corporate boards, all of that.
All of it. External pressures are gone. They are essentially marrying the law, promising that neither the terror of the state nor the affection for a friend will tip the scales of justice.
Wow. But the Constitution doesn't just rely on a solemn promise to ensure that neutrality, does it? It backs it up with a rather severe employment restriction.
It does. Article 124, Subclause 7, strictly prohibits a former Supreme Court judge from pleading or acting in any court or before any authority within the territory of India after they retire.
Let's unpack the mechanics of this, because why completely bar some of the greatest, most experienced legal minds from ever practicing law again? It feels almost punitive.
It does seem harsh at first glance.
Is the underlying logic to prevent them from currying favor with the government or, like, wealthy private parties while they're still on the bench, knowing they might want a lucrative consulting job or advocacy role later?
That is precisely the mechanism at work. This restriction is one of the foundational building blocks of judicial independence.
Okay.
We have to look at the human element here. Even a Supreme Court judge is a human being contemplating their future. If a sitting judge at age 63 knows their career as a highly paid advocate is waiting for them the day they turn 65.
Right. Their current judgments might not be fully insulated from the temptation of future employment prospects.
Exactly. If they were allowed to return to practice, they might subconsciously or even consciously soften a ruling against a powerful corporate litigant.
Hoping to be retained by them on a massive retainer after retiring.
Yes.
So it is essentially burning the ships once they reach the island. You are a Supreme Court judge, and when you are done, your days of standing at the bar and arguing a case are over.
Completely over.
I also imagine it preserves the hierarchy and dignity of the courts below them. I mean, imagine a former Supreme Court judge who spent years overturning high court decisions, suddenly appearing as a lawyer before a high court judge they might have once mentored or reprimanded.
Oh, the power dynamic in that courtroom would be entirely skewed. It would create an unbearable, invisible pressure on the lower court judges.
Yeah, how does a newly appointed high court judge impartially rule against the former Chief Justice of India, who is now arguing as a private lawyer?
It would be nearly impossible. So Article 124 operates as a dual shield. It protects the judge's integrity from future temptations while in office, and it protects the integrity of the lower courts from undue influence once that judge retires.
That makes perfect sense. Okay, so we know who they are, where they sit, when they retire, and the absolute ban on their post-retirement practice. We have built the fortress.
Now let's look at the arsenal inside it.
Exactly. What tools, what specific powers does the Constitution actually give the Supreme Court? The study materials categorize their powers into several distinct jurisdictions. Let's tackle original jurisdiction under Article 131 first.
Good place to start. To clarify the terminology for everyone, original jurisdiction basically means the power of a court to hear a case for the very first time.
So you aren't appealing a decision from a lower court?
Right. You aren't appealing. You're walking straight through the front doors of the Supreme Court to file your initial complaint. And the Supreme Court's original jurisdiction is highly exclusive.
Under Article 131, they only handle disputes where the fighting parties are the absolute heavyweights of the Indian Republic.
Yes.
And the materials define these heavyweights clearly. We're talking about disputes between the government of India and one or more states, or a fight between two or more states themselves.
Or a scenario where the government of India and some states team up on one side against other states on the opposing side.
Right. Do you have a practical example of that?
Sure. So if the state of Karnataka has a major intractable legal dispute with the state of Tamil Nadu over the sharing of river waters, or if the state of Kerala wants to challenge a specific federal law passed by the union government, arguing it infringes on state powers.
They do not go to a district court in Bangalore or Trivandrum?
No, they go straight to New Delhi. The Supreme Court acts as the ultimate, exclusive federal referee to keep the union intact and resolve boundary or power disputes.
So original jurisdiction under Article 131 is the arena for the massive family feuds between the center and the states. However, the notes point out a very specific historical exclusion.
Ah, yes.
This jurisdiction does not extend to disputes arising out of treaties, agreements, or covenants entered into before the commencement of the Constitution.
That is a fascinating historical carve-out. When India became independent, it integrated hundreds of princely states, often through complex treaties and covenants signed before the Constitution officially commenced in 1950.
Right.
The framers intentionally kept these pre-Constitution treaties out of this specific judicial arena. They wanted to prevent the newly formed Supreme Court from being immediately bogged down by massive historical grievances.
And royal entitlement claims that the new republic was desperately trying to settle politically, I assume?
Exactly.
Keep the court focused on the modern constitutional framework, not the ghosts of the princely past. That makes a lot of sense. And it transitions us perfectly from the federal referee to the ultimate protector of the individual citizen. Let's look at Article 32. Writ jurisdiction.
This is a big one.
Yeah, our study materials note that Dr. B.R. Ambedkar, the chief architect of the Constitution, called Article 32 the heart and soul of the Constitution. That is unparalleled praise. Why is this specific article elevated above all others?
Because, simply put, a right without a remedy is just an empty promise.
Okay.
You can write down all the fundamental rights you want, freedom of speech, equality, life, and liberty. But if the state violates them and you have no fast, guaranteed mechanism to enforce them, the paper they are written on is worthless.
Wow. So Article 32 empowers any individual to approach the Supreme Court directly for the enforcement of their fundamental rights.
Yes. If the state crosses the line, you do not have to endure the agonizingly slow climb from the district court to the high court over a span of decades.
You can knock directly on the doors of the highest court in the land.
And the court has the power to issue 5 specific types of writs to stop the state in its tracks.
The famous 5 writs, these are guaranteed to be the centerpiece of any constitutional law exam, so we need to do more than just read the Latin dictionary definitions. We really need to understand how they actually work in the real world. Let's break them down with vivid scenarios.
Let's do it.
First writ, habeas corpus.
So the literal Latin translation is to have the body. This writ is the ultimate historic safeguard against arbitrary state arrest.
Okay, give me a scenario.
Imagine a scenario where a journalist is investigating local corruption. In the middle of the night, local police break down their door, put them in an unmarked car, and take them away without a warrant, without informing their family, and without presenting them before a magistrate within 24 hours as the law requires.
The state has simply vanished a citizen.
Exactly. So the journalist's lawyer or family runs to the Supreme Court and files for habeas corpus.
If the court issues the writ.
They are commanding the police or the state to physically produce the detained person, to have the body in front of the court, and justify the legal grounds for their detention.
And if they can't?
If the state cannot provide a valid, lawful reason, the court orders their immediate release. It cuts through all bureaucratic red tape.
A vital mechanism against a police state. Okay, second writ.
Mandamus.
Mandamus translates to we command. This writ is about forcing a public authority to do their job.
Do their job, okay. Let's say a young entrepreneur fulfills every single legal requirement, passes every inspection, and pays every fee to get a license to open a pharmacy. But the local licensing officer, perhaps holding a grudge or looking for a bribe, simply shoves the application in a drawer and refuses to issue the license.
So they're legally bound to issue it, but they are stalling.
Yes.
The entrepreneur's fundamental right to practice a profession is being violated by administrative inaction.
Precisely. The entrepreneur approaches the court, and the court issues a writ of mandamus. It is a direct, legally binding judicial command to that officer.
Perform your public duty and issue this license immediately.
Yes. It corrects a failure to act.
So in mandamus is the court acting as a cattle prod to force action. The third writ seems to be the exact opposite. Prohibition.
It is the exact opposite. Prohibition is a judicial stop sign.
A stop sign.
It is issued by a higher court, like the Supreme Court, to a subordinate court, or a quasi-judicial body. Imagine a local family court, which only has the legal authority to hear divorces and child custody cases, suddenly decides it wants to conduct a murder trial.
Wait, what? They can't do that.
Right. It is wildly exceeding its legal jurisdiction. So before they can even strike the gavel and issue a verdict, One of the parties runs to the Supreme Court.
And the Supreme Court issues a writ of prohibition.
Yes, it halts the proceedings in their tracks. It tells the lower court, stop right there. You do not have legal authority to hear this. Put the files down.
It is preemptive. It prevents an invalid legal proceeding from continuing.
Exactly.
But what if they are too late? What if the family court rushed through the murder trial and already issued the guilty verdict? That brings us to the fourth writ, right? Certiorari.
Exactly. Certiorari means to be certified. It functions similarly to prohibition, dealing with courts exceeding their power, but it is usually issued after the flawed order or judgment has already been passed. If the lower court acted completely without jurisdiction, or if there is a glaring, massive error of law on the face of the record, the Supreme Court uses certiorari to reach down, grab that verdict, and rip it up. It quashes the order.
The materials also mention certiorari can be used if a court violates the rules of natural justice. Let's clarify that jargon. What does violating natural justice look like?
The rules of natural justice are the fundamental principles of fairness. The most common one is audi alterum partem, which simply means listen to the other side.
Okay, that sounds basic enough.
Imagine a government tribunal revoking a doctor's medical license based on a complaint, but they completely refuse to let the doctor present evidence in their own defense or cross-examine the accuser.
They just hold a secret meeting and strip the license.
Yes. Even if the tribunal had the jurisdiction to revoke licenses, the process violated natural justice. The Supreme Court would use certiorari to quash that revocation because the procedure was fundamentally unfair.
You cannot take away someone's livelihood without letting them speak. Makes total sense. The fifth and final writ. Quo warranto.
Meaning, by what authority? This writ is used to question the legality of a person's claim to a public office.
Give me an example of that.
Let's say the law strictly mandates that the chief medical officer of a state hospital must hold an advanced medical degree and have 10 years of surgical experience. But through sheer political nepotism, the health minister appoints his nephew, who only has an undergraduate degree in marketing, to the position.
Oh, wow. So the nephew has usurped a public office he is entirely unqualified for.
Exactly. A citizen files for quo warranto. The court brings the nephew in and asks, by what legal authority do you hold this public office?
And when the nephew cannot produce the legally required medical qualifications,
The court uses this writ to instantly remove him from the position. It protects public offices from illegal usurpation.
So to recap the arsenal for everyone listening, habeas corpus frees you from illegal detention. Mandamus forces an official to do their job. Prohibition stops a lower court before it breaks the rules. Certiorari rips up a lower court's illegal verdict after the fact. And quo warranto kicks unqualified people out of public office.
That's a great summary.
Those 5 writs are the judicial superhero landing. They step in when the state overreaches. Now we move from the dramatic constitutional emergencies to the heavy, grinding machinery of regular justice. Appellate jurisdiction, covering Articles 132, 133, and 134.
Right, and this represents the vast bulk of the Supreme Court's day-to-day docket. Original jurisdiction is rare. Writ jurisdiction is specific. But appellate jurisdiction is constant.
It's the daily grind.
The Supreme Court serves as the ultimate court of appeal from judgments of the high courts. If a high court confirms a death sentence in a massive criminal trial, or if 2 multinational corporations have fought over a billion-dollar patent infringement through the trial courts and the high court,
The losing party has the right to appeal to the Supreme Court. The apex court is the final set of eyes to ensure the law was applied correctly.
Exactly.
But the Constitution doesn't just grant automatic appeals for everything, otherwise the court would drown in minor disputes. The notes highlight Article 136, special leave to appeal. This is explicitly described as a discretionary power, not a matter of right. How does this differ from a regular appeal?
That distinction is paramount. In a standard civil or criminal appeal, the statutes often give you a legal right to be heard by the Supreme Court if certain criteria are met. You file your paperwork, and the court schedules a hearing.
Right.
But under Article 136, you do not have a right. You are essentially filing a petition begging the Supreme Court for special permission to appeal a judgment from any court or tribunal anywhere in India except military tribunals.
So it is an appeal asking for permission to appeal.
Yes. The Supreme Court does not have to take the case. I can read your petition and dismiss it in 2 minutes if they feel justice was already served below.
When do they actually grant it?
They grant this special leave only when they spot a grave, shocking miscarriage of justice, or when the case presents a novel, unanswered question of law that needs to be settled to guide all the courts in the country.
It serves as a vital pressure valve. It allows the Supreme Court to reach into any case in the country to correct a massive wrong without being forced to hear every single minor grievance.
Exactly.
That brings us to Article 143, Advisory Jurisdiction. This is a fascinating departure from normal judicial work. Normally, a court waits for two parties to fight and then decides a winner. But under 143, the President of India can refer a question of law or a question of fact to the Supreme Court for its opinion.
Yes.
The materials specifically mention two landmark references, the Burabari case in 1960 and the Ayodhya dispute reference in 1993. Let's dig into the history here. Is the Supreme Court essentially acting as the president's high-powered legal consultant?
They are acting as the ultimate constitutional advisor to the executive branch. Let's look at the Inri Barubar Union case of 1960 to see how it works. Prime Minister Jawaharlal Nehru entered into an agreement with Pakistan to resolve border disputes, which involves ceding a small piece of Indian territory, Barubari, to Pakistan. Massive political uproar followed.
I can imagine.
The central constitutional question was, does the executive government have the power to just give away Indian territory through a treaty, or does it require Parliament to amend the Constitution?
So before making a move that could be ruled unconstitutional later, the president invoked Article 143 and sent the question to the Supreme Court.
Precisely. The president asked the court for its legal opinion on the mechanisms of ceding territory. The Supreme Court advised that, no, the executive cannot unilaterally cede territory. It requires an amendment to the Constitution under Article 368.
And what happened?
Based on that advice, the government passed the 9th Constitutional Amendment Act to implement the treaty. It avoided a massive constitutional crisis after the fact.
So it's a conversation between the branches to clarify the law before taking a massive political step. But does the president have to follow the advice? If the Supreme Court says don't do it, can the president do it anyway?
Technically, yes. The opinion given by the Supreme Court under Article 143 is formally advisory. It is not a legally binding decree on the president.
Oh, really?
However, it carries immense persuasive value. Politically and practically, if the highest court tells the government an action is unconstitutional, ignoring that advice is almost impossible.
And what about the other side? Does the Supreme Court have to answer the president? The notes mention the Ayodhya dispute reference.
That is the perfect example of the court's boundary. In 1993, following the demolition of the Babri Masjid, the president sent a reference to the Supreme Court under Article 143 asking a very specific question.
What was the question?
Whether a Hindu temple or any Hindu religious structure existed prior to the construction of the Ram Janmabhoomi Babri Masjid in the area on which the structure stood.
Wait, that isn't a question of constitutional law. That is a question of history and archaeology.
Exactly, and the Supreme Court recognized that. The court famously returned the reference unanswered.
Wow, they just sent it back.
They stated that the question was superfluous and unnecessary, and essentially it was a historical and political dispute, not a strictly legal one that the court should opine on via advisory jurisdiction.
That cemented a crucial precedent then. The Supreme Court can politely but firmly decline to give an opinion if they feel the reference is inappropriate, purely political, or outside their judicial competence.
They are advisors, not servants to the executive's political problems.
That is a phenomenal display of judicial restraint. All right, two more major powers for the Supreme Court from our notes. Article 129 designates the Supreme Court as a court of record. What are the mechanics of this?
A court of record has two vital attributes. First, their records, their written judgments, proceedings, and acts are preserved for perpetual memory. They have absolute evidentiary value.
Okay, meaning what in practice?
If you bring a Supreme Court judgment into a district court in rural India, it cannot be questioned. It is the truth. This links directly to the doctrine of stare decisis under Article 141, which explicitly states that the law declared by the Supreme Court shall be binding on all courts within the territory of India.
So when the Supreme Court speaks, they aren't just deciding a winner for the two people in the room. They are effectively writing the law of the land, and every magistrate in every village has to follow it until Parliament changes the underlying statute or a larger bench of the Supreme Court overturns it.
Precisely. And the second attribute of a court of record is the inherent power to punish for contempt of itself.
Contempt of court.
Yes. If someone scandalizes the court, launches vicious, unfounded attacks on a judge's character, or willfully disobeys a direct Supreme Court order, the court has the power to penalize them with fines or imprisonment.
And this isn't about protecting the fragile egos of the judges, right?
Oh, it is vital for maintaining the court's authority. If people can openly mock and ignore Supreme Court rulings without consequence, the rule of law collapses.
Makes sense. If the Supreme Court can hear cases from any lower court, issue sweeping writs, advise the president, and mandate the law of the land, they must have some way to correct their own mistakes, right? They are human. If they make a massive error and they are the final court, who fixes it? That leads us to Article 137, Review Jurisdiction.
The Constitution recognizes judicial fallibility. Article 137 provides a narrow but essential window. It allows the Supreme Court to review its own judgments.
But you can't just ask for a review because you are unhappy you lost.
Oh no, the threshold is extremely high. You must show there is an error apparent on the face of the record, a glaring, obvious legal mistake in the judgment, or that significant transformative new evidence has emerged that was impossible to find during the original trial.
It ensures that the absolute finality of the Supreme Court's decisions doesn't come at the cost of actual justice. Which brings us to the ultimate wildcard, the absolute superpower of the apex court, Article 142. The materials state, this article grants the Supreme Court the power to pass any decree or make any order necessary for doing complete justice in any cause or matter pending before it. Complete justice. That is an incredibly vast mandate.
It is a power entirely unique to the Indian judiciary. Article 142 is an extraordinary, wide-ranging, equitable power.
How does it work?
The framers understood that laws are written generally, and sometimes strict, blind adherence to procedural law might actually lead to a deeply unjust outcome in a specific, unique case. Article 142 allows the Supreme Court to step outside those strict procedural bounds to ensure fairness.
So if the existing law is silent on a specific nuance, or if following the strict letter of the law creates a tragic inequity, the court can invoke 142 to mold a new type of relief that achieves complete justice. Our study materials connect this directly to the concept of judicial activism and public interest litigations, or PILs. They cite the famous Husanara Khatun case from 1979. Can we deep dive into how Article 142 and PILs worked in that scenario?
Oh, Husanara Khatun is a watershed moment in Indian legal history. A newspaper published a shocking exposé about the prisons in the state of Bihar. There were thousands of undertrials, people accused of minor crimes who were waiting for their trials to start languishing in agonizing jail conditions for years.
Wait, for years?
Yes. The tragedy was that many had been in jail awaiting trial for 3, 5, or 7 years for minor thefts, where the maximum sentence if they were found guilty was only 6 months.
So even if they were guilty, they had already served 10 times the maximum sentence just waiting for a judge to hear their case. The procedural machinery of justice had completely failed.
Utterly failed. A lawyer filed a public interest litigation directly in the Supreme Court based on the newspaper article. Now, strictly procedurally, a court usually deals with individual petitions one by one. But facing this massive, systemic human rights disaster, the Supreme Court leaned on its broad constitutional powers, interpreting Article 21, the right to life and liberty, to include the right to a speedy trial.
And utilizing powers akin to the mandate of complete justice under 142.
They didn't ask for thousands of individual bail applications. They passed sweeping, unprecedented orders resulting in the immediate release of roughly 40,000 under trials across the state.
Wow, that is the essence of judicial activism. It's the court refusing to shrug and say, well, the procedures are slow, too bad. It is the constitutional engine that allows the court to actively shape societal justice and invent new remedies when an emergency demands it and the executive is lagging.
Beautifully put.
Okay, we have surveyed the absolute top of the pyramid, the Supreme Court, the federal referee, the protector of fundamental rights, the ultimate advisor, and the dispenser of complete justice. But India is a continent-sized nation. One court in New Delhi, even with 34 judges, cannot handle the legal ailments of a billion people. We must move down one tier to the state guardians, the high courts.
So now we enter Part 6, Chapter 5 of the Constitution, stretching from Articles 214 to 231. This section deals entirely with how the constitutional framework adapts at the provincial state level.
Article 214 is the anchor, right? It boldly and simply mandates, there shall be a high court for each state.
It does.
But if we look at a political map of India today, we know that isn't strictly mathematically true. We have 28 states and 8 union territories, but we don't have 36 high courts.
Well, the framers were practical. They anticipated that administrative and economic realities wouldn't always support a massive high court for every single small state or newly formed territory.
Ah, okay.
That is why Article 231 empowers Parliament to establish a common high court for 2 or more states. The classic example highlighted in the notes is the Punjab and Haryana High Court, located in Chandigarh, which serves both of those major states, plus the Union Territory of Chandigarh itself.
Furthermore, Article 230 allows Parliament to extend the jurisdiction of an existing high court to cover a union territory or exclude it. So the architecture is highly flexible, adapting to population density and geography. Let's look at who sits on these state benches. Article 216 says every high court consists of a chief justice and such other judges as the president may from time to time deem necessary.
Yes.
And Article 217 covers how they get there. When we looked at the Supreme Court, it was a straight line. The president appoints them. But for the high courts, the appointment process becomes a much more crowded room.
It becomes a very complex triangle of consultation. To appoint a regular high court judge, the president must consult 3 distinct entities.
Who are they?
First, the Chief Justice of India. This maintains the vertical national judicial link, ensuring the apex court has a say in state-level appointments.
Makes sense.
Second, the governor of the specific state. This brings in the state-level executive perspective, acknowledging that this judge will operate within their borders.
Okay.
And third, they must consult the existing Chief Justice of that specific high court because they are the one managing the local docket and know what kind of judicial expertise the court desperately needs.
You have the national judiciary, the state executive, and the state judiciary all weighing in to fill one seat. It is a fascinating web of checks. And what are the qualifications to sit in that seat?
To be a high court judge, you must be a citizen of India, naturally. But the sources show 2 distinct career paths to the bench.
Oh, what are?
You must have either held a judicial office in the territory of India for at least 10 years, meaning you've worked your way up through the grueling ranks of the subordinate district courts and proven your mettle as a career judge. Or you must have been an advocate of a high court for at least 10 years. This dual pathway is intentional. It ensures the high court bench is a blend of seasoned, methodical trial judges and brilliant, battle-tested litigation lawyers who understand the practical realities of arguing complex cases.
And earlier we noted the retirement age for Supreme Court judges is 65. When does a high court judge have to hang up their robes?
They hold office until the age of 62.
That 3-year differential is incredibly important. I imagine it creates a natural pipeline. The most brilliant senior high court judges, approaching 62, are often elevated to the Supreme Court, giving them 3 more years to shape national jurisprudence.
That happens very frequently.
Now, let's wade into a highly contentious part of the high court structure. Article 222, the transfer of judges. The study materials state that the president may, after consulting the Chief Justice of India, transfer a judge from one high court to any other high court across the country.
Yes, the transfer provision. It is a unique feature of the Indian Constitution designed to foster national integration.
How so?
The idea is that the administration of justice shouldn't get bogged down by localized nepotism, entrenched regional biases, or a judge becoming too comfortable with the local political elite. When a judge is transferred, the Constitution guarantees them a compensatory allowance determined by Parliament to offset the massive disruption of uprooting their family and moving their entire life 1,000 miles away.
But let me push back hard on this transfer provision because our study notes explicitly raise this as a problem. Let's play out a scenario.
Okay.
Suppose a courageous high court judge in a particular state starts striking down unconstitutional policies passed by the local state government. The chief minister is furious. Couldn't that chief minister just call up their political allies in the union government, ask the president to invoke Article 222, and transfer this troublesome judge to a remote high court on the other side of the country?
That is the fear, yes.
The study notes explicitly ask, can the president transfer a judge of a high court to another court without the consent of the transferred judge? And the answer provided is undeniably yes. How is that fair to the judge? How is that fair to the state losing a brilliant jurist? Doesn't this completely destroy judicial independence if the executive can just exile you for doing your job?
You have zeroed in on the exact friction point that has generated massive constitutional litigation, notably in cases like Sankel-Chan-Chef during the emergency era, where mass transfers were perceived as punitive.
So it actually happened.
Yes. On the surface, if the executive had the unilateral power to shuffle judges purely as a punishment for defying them, judicial independence would indeed be dead. However, you have to look at the vital safeguard built directly into the text of Article 222.
Which is?
The president can only order this transfer after consultation with the Chief Justice of India.
So the Chief Justice of India acts as the shield against the executive sword.
Precisely. Over time, the Supreme Court has interpreted this provision stringently. They have ruled that a transfer cannot be a punishment. It cannot be deployed just because a judge is unpopular with the local political machine or because their judgments are inconvenient.
So what justifies a transfer?
A transfer must be strictly in the public interest or for the better administration of justice. And crucially, the Chief Justice of India's opinion on whether a transfer meets that criteria is paramount. The mandatory consultation prevents the executive from using geographic exile as a weapon to cow an independent judge.
So even though the judge's personal consent isn't required to move them, the highest judicial officer in the land has to review the file and agree that the move is necessary for the justice system, not for political vengeance. That adds a crucial layer of armor.
It does.
Okay, moving on from how the high courts are built and protected, let's look at their weaponry. And this brings us to what is arguably the most important comparison in this entire syllabus unit. Every Osmania LLB student listening needs to star, highlight, and underline this next section. It is the distinction between Article 32 and Article 226.
Oh, it is the classic exam question and a fundamental non-negotiable concept of Indian constitutional law.
We already established heavily that Article 32 allows citizens to approach the Supreme Court directly for the enforcement of fundamental rights using the 5 prerogative writs: habeas corpus, mandamus, prohibition, certiorari, and quo warranto.
Correct. Now we flip to Article 226, which grants the state high courts the exact same power to issue those exact same 5 writs.
So if they both issue the exact same writs, what is the practical difference? Why have both? The study notes lay out 3 major distinctions: purpose, nature, and scope. Let's dissect purpose first.
Okay. The Supreme Court's power under Article 32 is highly focused. They can only issue writs for the enforcement of fundamental rights, the core rights guaranteed in Part 3 of the Constitution, like the right to life, equality, and free speech.
Right.
If your dispute does not involve a fundamental right, Article 32 cannot help you. But the High Court, under Article 226, is granted the power to issue writs for the enforcement of fundamental rights, and here's the critical phrase, for any other purpose.
Any other purpose. That sounds incredibly broad. What does that actually mean in a courtroom?
It means the High Court's jurisdiction is vastly wider. They can issue writs to enforce not just core constitutional fundamental rights, but also ordinary legal rights, statutory rights, or administrative rights.
Give me an example.
If a local municipality violates a specific zoning statute and illegally demolishes your non-residential shed, that might not be a grave fundamental rights violation that the Supreme Court will hear under 32. But it is a clear violation of your legal statutory right. The High Court can issue a writ under 226 to stop them or demand compensation.
I have a metaphor for this. This is a fascinating aha moment. Article 32 is like the elite express train. It only stops for massive multi-car fundamental rights emergencies, but you have a guaranteed ticket to get on.
I like that.
Article 226 is the local commuter train. It covers a much wider route. It stops at a lot more stations, including ordinary legal and statutory rights, but it operates differently.
That is a brilliant analogy, and it leads perfectly into the second major distinction outlined in our notes, the nature of the power. Why is your ticket on the express train guaranteed? Because Article 32 is, in and of itself, a fundamental right listed in Part 3.
Meaning the Supreme Court has to hear it.
The Supreme Court is constitutionally duty-bound to grant relief if a substantive fundamental right is actively being violated. They generally cannot refuse to hear you. But the High Court's writ power under Article 226 is a discretionary remedy.
So the conductor of the local train has the discretion to check your ticket and tell you to catch a different train.
Exactly. The High Court can look at your case and say, yes, your legal right was technically violated by the municipality. However, you waited 6 years to file this petition.
So timing matters.
This introduces the legal concept of laches, which means unreasonable delay. The law assists those who are vigilant, not those who sleep on their rights. The High Court can reject your writ purely on the grounds of delay.
What else could they reject it for?
Or they might invoke res judicata, meaning the matter has already been fully judged and decided in a lower civil court, and you can't just try again via a writ petition hoping for a different outcome.
Oh, that makes sense.
Or, most commonly, they might say, the specific statute you are arguing about has its own built-in appellate tribunal. You must exhaust that alternative remedy first, before asking us for a writ. The Supreme Court under Article 32 does not usually have the luxury of pointing to alternative remedies when a fundamental right is bleeding.
Okay, we have purpose and nature. The third distinction is scope, which brings in geographical territorial limits.
Very simply, the Supreme Court's reach is the entire territory of India. A writ from New Delhi binds an officer in a remote village in Tamil Nadu. A high court, however, can generally only issue writs within its own territorial jurisdiction.
Meaning the borders of its state, or if the specific cause of action arose within its territory. A judge in the Bombay High Court cannot issue a writ of mandamus against a police officer operating purely in Kolkata. Our sources mention a specific Supreme Court holding regarding this overlap. Since both courts can enforce fundamental rights, if a citizen's right to free speech is violated, where should they go first? The express train or the local train? The notes cite cases like Fertilizer Corporation of India and PN Kumar versus Municipal Corporation of Delhi. Let's break down the court's practical guidance here.
In those cases, the Supreme Court acknowledged that while Article 32 is a basic feature of the Constitution, practically speaking, the judicial system would collapse if every single fundamental rights violation in a nation of 1 billion people went straight to New Delhi.
So what is the rule?
The court established a rule of practice where relief through the High Court is available under Article 226. The aggrieved party should first approach the High Court.
Why mandate that detour?
3 reasons. First, the High Court is geographically closer and more accessible to the citizen. Second, it desperately helps manage the Supreme Court's massive docket, allowing the apex court to focus on national constitutional interpretation rather than local disputes.
And the third reason?
And third, because Article 226 covers any other purpose, the High Court can actually look at a broader, more holistic range of issues surrounding the violation, whereas the Supreme Court would be strictly confined to the fundamental right aspect.
So even though you have the express ticket, the system strongly prefers you try the local route first unless it's a matter of absolute immediate national urgency. It's a highly pragmatic approach to justice delivery.
Exactly.
Okay, we have spent a lot of time in the clouds. We've seen the constitutional courts, the supreme architecture of New Delhi, and the powerful state high courts, but let's be entirely real. The vast, overwhelming majority of ordinary citizens will never step foot inside the Supreme Court and might only rarely visit their state's high court.
That's very true.
When a normal person has a property line dispute or files a divorce or is accused of a local theft, where do they actually experience the justice system? They experience it down in the district courts, the subordinate judiciary.
And that is covered in Chapter 6, Articles 233 to 237. We are looking at the foundation of the judicial pyramid. It is vital to study this because without a robust, fearless, and independent subordinate judiciary handling the millions of daily cases, the grand promises made by the Supreme Court are just empty ink on paper.
Let's look at the district judges first, the highest judicial authority within a local district. Article 233 covers their appointment. And here, we immediately see a massive constitutional shift in power.
How so?
Well, for the Supreme and High Courts, the President of India is doing the appointing. But down at the district level, the Constitution states that the appointment, posting, and promotion of district judges shall be made by the governor of the state.
Yes. The state executive suddenly steps into the process. The local government has the pen. However, look at the crucial, binding, qualifying phrase right after that in Article 233.
Let me check. The governor must make these appointments in consultation with the High Court, exercising jurisdiction in relation to such state.
Exactly. So the governor signs the paper, but the High Court is holding their hand.
And this theme continues forcefully into Article 235, which talks about the ongoing control over subordinate courts. It says the control over district courts and all courts subordinate to them. This includes the posting, promotion, and the granting of leave for anyone in the state judicial service holding a post inferior to a district judge shall be vested entirely in the High Court.
Yes.
I'm looking at this structure, and it seems like the framers were absolutely obsessed with making sure the executive branch, the local politicians, couldn't just handpick or manage their own judges at any level.
Obsessed is the perfect word, and they had every right to be. This is the constitutional wall built to protect judicial independence at the grassroots level. Imagine a scenario where Article 235 didn't exist.
Okay.
Imagine if the local district magistrate or the chief minister could directly control the promotions, transfers, or even the vacation leave of the local civil judge. What happens when a case involving a massive land grab by the chief minister's brother lands on that civil judge's desk?
If the judge knows the politician controls their next promotion, the system collapses into corruption and subservience instantly.
Exactly. So by vesting total administrative control in the High Court through Article 235, the Constitution essentially builds an invisible fortress around the subordinate judges. The governor technically signs their entry papers, but from that day forward, the High Court pulls the strings on their career progression.
That is amazing. It ensures that the judicial chain of command remains completely unbroken and insulated. A junior civil magistrate looks up to the district judge, who looks up to the High Court Chief Justice, who looks up to the Chief Justice of India.
Yes. At no point in that vertical chain does a local politician or a state executive officer have the unilateral power to derail a judge's career or punish them for a ruling.
That exact obsession we just talked about, building a fortress to protect the judges from the politicians, leads us perfectly into the central philosophical pillar of this entire syllabus unit. It is the invisible shield that covers everything we've discussed for the past 45 minutes. The independence of the judiciary.
The biggest topic of all.
Why are all these complex appointment rules, these transfer protections, these powerful oaths, and these jurisdictional boundaries so painfully necessary?
Well, our study materials outline the why very clearly, breaking it down into fundamental democratic needs. First, independence ensures actual checks and balances among the three organs of the government.
Right.
Without an independent judiciary, the legislature could pass wildly unconstitutional laws, stripping away rights. The executive police force could enforce those laws brutally, and the citizen would have nowhere to turn. The judiciary is the emergency brake on the state's momentum.
The sources summarize it perfectly, actually. They say it prevents arbitrary actions by the executive and legislature.
Second, it provides a neutral, fearless forum for resolving disputes. And this isn't just about citizen A suing citizen B over a fence. It is about a citizen suing the awesome power of the state, or a state suing the powerful central union. You need an umpire who isn't paid by one of the teams. Third, it is the only way to protect the fundamental rights and liberties of individuals. And fourth, it upholds the ultimate principle of constitutional supremacy. In India, the Constitution is the supreme law, not the parliament of the day.
So how does the Constitution practically build this shield? We've touched on a few pieces, but let's consolidate the constitutional provisions ensuring judicial independence explicitly listed in the materials. Number 1, security of tenure under Articles 124 and 217.
This is the bedrock. A judge cannot be fired just because the prime minister or the chief minister strongly disagrees with their rulings. Removing a Supreme Court or High Court judge requires a grueling, rigorous process of impeachment by Parliament.
And it cannot be initiated for political reasons.
No, it can only be done on two very specific, difficult-to-prove grounds. Proven misbehavior or incapacity, as stated in Article 124, Subclause 4. The threshold is astronomically high. It requires a special, overwhelming majority in both houses of Parliament.
Wow. Has it ever happened?
It is so mathematically and politically difficult that an impeachment has almost never succeeded in Indian history. Justice V. Ramaswamy faced impeachment in the 1990s, and while the inquiry found misbehavior, the motion failed in Parliament because a political party abstained from voting.
So even when there is an inquiry, the political math is nearly impossible.
This proves how impenetrable the tenure shield is. It gives judges the ultimate courage to rule against the government of the day without fear of losing their job tomorrow.
Number 2 on our list, fixed service conditions. The notes state that judges' salaries, allowances, and pensions are charged upon the consolidated fund under Articles 125 and 221, and critically, these cannot be altered to their disadvantage after appointment.
Yes.
Let's unpack the mechanics of this consolidated fund detail. That is essentially saying the legislature cannot use the power of the purse to threaten the courts. If Parliament is furious about a Supreme Court ruling striking down a major law, they cannot retaliate by voting to cut the judges' paychecks in half the next day.
Exactly. It is guaranteed financial independence, ensuring intellectual independence. They do not have to lobby Parliament every year begging for their salaries. You cannot starve the judiciary into submission. The money is automatically drawn. It is not subject to the annual political circus of the budget vote.
Number 3 on the list is Article 50, which is a directive principle of state policy. It specifically mandates the state to take steps to separate the judiciary from the executive in the public services.
It is a philosophical constitutional mandate guiding the whole structure, ensuring that the person who arrests you is never the person who judges you.
We also have the sweeping power of judicial review under Articles 13, 32, and 226, which we extensively discussed, the unyielding power to strike down laws, and the prohibition on practice after retirement under Article 124, ensuring no future favors are sought.
We have built an incredible fortress.
But this brings us to the final and undoubtedly the most explosive, controversial mechanism for independence in Indian constitutional history. What happens if the executive realizes they cannot fire a judge and they cannot cut a judge's pay?
They will naturally try to control the entry into the fortress. They will try to make sure only their ideological friends get hired in the first place.
And that profound tension brings us to the appointment procedure and the dramatic evolution of the collegium system. This is where the pristine text of the Constitution collides violently with the reality of political power struggles. This is the climax of this unit.
It really is.
Our study materials dedicate a massive amount of space to this evolution. It is the delicate, volatile balance between keeping the executive out to maintain pure independence while also ensuring the judiciary remains accountable to a democratic society. How does India manage this? Let's go back to the raw text.
Let's look at it.
Article 124 says the president appoints Supreme Court judges after consultation with such of the judges of the Supreme Court and of the high courts as the president may deem necessary. The absolute key word there is consultation.
Right? Consultation. And for the first few decades of the Republic, through the 1950s and 60s, consultation generally functioned as a cooperative, respectful dialogue between the executive and the senior judiciary. But the executive ultimately held the upper hand.
How so?
If the government really wanted a specific lawyer on the bench or really didn't want a certain judge elevated, they could usually push their preference through.
Okay.
But as the political landscape grew more turbulent in the 1970s, particularly during the emergency era, the judiciary began to face immense pressure. There was a growing, terrifying fear among jurists that the executive was actively trying to pack the courts with committed judges.
Committed to what?
Committed to the ruling government's political ideology rather than the neutral text of the Constitution.
A completely compliant judiciary. Which leads us to the three landmark cases that completely rewrote how the word consultation is understood, fundamentally changing how appointments work. If you are a law student, you must know the narrative arc of these cases. Let's walk through this historical thriller. It starts with the first judge's case in 1981, S.P. Gupta v. Union of India.
In the first judge's case, the Supreme Court was grappling with executive interference. But they ultimately took a conservative reading of the text. They acknowledged the supreme significance of judicial independence, but they held that the word consultation in the Constitution did not mean concurrence.
Meaning what?
Meaning the Chief Justice's opinion on an appointment was highly important, and the executive had to listen to it. But the executive could still ultimately override the Chief Justice if they had good and cogent reasons. The ultimate power of appointment still lay heavily with the central government.
The executive was still the CEO making the final hiring decision. But then, 12 years later, we get the seismic shift, the earthquake in Indian constitutional law, the second judge's case in 1993, specifically the Supreme Court Advocates on Record Association case.
This case turned the entire constitutional system upside down. The Supreme Court looked back at the intervening decade of political pressures and realized that if the executive retains the final say on who gets to be a judge, true, fearless independence is a dangerous illusion.
So what did they do?
They radically reinterpreted the word consultation in Article 124. They ruled that in the matter of appointments and transfers, consultation effectively means concurrence. They declared that the opinion of the judiciary has absolute primacy.
That is a staggering interpretation. They essentially rewrote the dictionary definition of the word to save the institution.
They did. They stated that the president is essentially bound by the advice of the Chief Justice of India. The executive cannot appoint someone the Chief Justice rejects, and they cannot easily reject someone the Chief Justice strongly recommends. It was a massive, unprecedented transfer of power from the executive branch back into the hands of the judiciary.
But giving one single person, the Chief Justice of India, the absolute final say over every appointment in the country is also dangerous. So to refine how the Chief Justice makes these monumental decisions, we get the third judge's case in 1998, which was actually a presidential reference under our old friend, Article 143.
Exactly. The president asked the court to clarify how this new primacy worked. The third judge's case formally established what we now call the collegium system.
And how does that work?
It clarified that the Chief Justice of India cannot act alone as an all-powerful judicial monarch. The opinion of the judiciary must be formed collaboratively by a collegium, a group, comprising the Chief Justice of India and the 4 senior-most judges of the Supreme Court. This elite group of 5 make the binding recommendations for appointments and transfers.
I want to try a metaphor to explain this massive shift. Before 1993, the system was like a corporate hiring process where the CEO, the president, asked the HR department, the chief justice, for recommendations, but the CEO could ultimately hire whoever they wanted.
Yeah, that fits.
After the second and third judges' cases, the collegium system acts like an ultra-powerful, independent HR committee. The CEO still formally signs the offer letter and issues the warrant of appointment, but the HR committee completely controls who gets interviewed, who gets the job, and they hold an absolute veto.
Yes.
The CEO's role is largely reduced to conducting background checks and rubber-stamping the committee's choice.
That is a highly accurate way to visualize the mechanics of the collegium.
Now, I want to pause here. Our guidelines for this deep dive dictate absolute neutrality regarding politically charged material. The study sources explicitly, repeatedly note that the collegium system is highly controversial. We are not taking sides on whether the collegium is the greatest safeguard of democracy in the world or an overreach of judicial power.
Absolutely.
We are simply looking at the text, the history, and the outcome. The original text of the Constitution charted a delicate middle course between total executive appointment, like how the president nominates judges in the U.S., and total judicial self-selection. But through these 3 landmark cases, the Indian judiciary interpreted the Constitution to ensure that they, and they alone, have the final say, prioritizing their institutional independence above all other considerations.
That is a perfectly impartial and legally accurate summary. The legal reasoning embedded in the sources is clear. The judiciary genuinely believed, based on traumatic historical experiences with political overreach, that protecting the fundamental rights of everyday citizens was literally impossible if the political executive retained the power to pack the constitutional courts with loyalists.
Or punish fiercely independent judges via arbitrary transfers.
Right. They felt they had to build an impenetrable fortress around themselves to save the republic. The controversy, as the academic notes rightly point out, arises because this system effectively means judges appoint their own colleagues and successors.
A closed-loop system of self-selection that is quite rare in modern global democracies.
Yes, very rare.
Which brings us to the inevitable other side of the coin, the final topic in our syllabus unit, judicial accountability. It is the fundamental question of power. If the executive cannot appoint them, the legislature cannot easily transfer them, and Parliament cannot remove them without an almost mathematically impossible impeachment process. How do we ensure the judges do not become an untouchable law unto themselves?
It is the oldest question in political science. Independence without accountability is tyranny. The Indian system relies heavily on maintaining accountability through rigorous internal and structural mechanisms rather than external political control.
What are those internal mechanisms?
First, there is the strict constitutional oath of office we discussed at the very beginning. It legally and morally binds their conscience to the Constitution, not to a political party. Second, there is the rigid appellate structure itself. A district judge who makes an arbitrary, terrible ruling is accountable to the High Court, which will publicly review and quash their judgment. A High Court judge is accountable to the Supreme Court. There's constant oversight from above.
And there is the doctrine of precedent, stare decisis, that we talked about under Article 141. They cannot just wake up, walk into the courtroom, and invent new laws every day based on their mood. They are strictly bound by the historical records, previous larger bench decisions, and the text of the statutes.
Exactly. They're tethered to the law. Furthermore, their judgments are entirely public. They are subjected to intense daily academic, journalistic, and public scrutiny. If a Supreme Court bench delivers a flawed judgment, the legal community dissects it instantly.
And finally, there remains the ultimate, though incredibly rare, threat of parliamentary impeachment under Article 1, 2, and 4. As we noted, it may be mathematically difficult, but the process exists on paper, and the fact that it has been initiated in the past serves as a powerful, lingering deterrent against gross, undeniable misbehavior or open corruption.
Yes, the threat is always there, structurally.
Wow. We have covered a truly massive amount of ground today. We started at the soaring architecture of the Supreme Court in New Delhi. We examined its exclusive original jurisdiction resolving state feuds, and we took a deep dive into the sweeping, extraordinary power to do complete justice under Article 142, looking at how it birthed judicial activism in cases like Husinara Khatun.
We rode the guaranteed express train of Article 32 to protect our fundamental rights, and we explored the wider discretionary local train of the High Court's Article 226 writ powers.
We traced the complex chain of command all the way down to the subordinate judiciary, seeing how the constitutional wall of Article 235 protects the local district magistrates from the grasp of local political pressure.
And we wrapped all of those mechanics in the ironclad armor of judicial independence, exploring the fascinating, turbulent, and controversial evolution of the collegium system through the drama of the first, second, and third judges' cases.
If you are sitting down for that Constitutional Law 2 exam at Osmania University, you now have the deep conceptual framework and the specific case law to confidently tackle any question they throw at you regarding Unit 2.
It is ultimately a study in balance. The framers designed a judicial system that attempts to be powerful enough to halt the awesome machinery of the government when it overreaches, but structured enough to remain deeply bound by the text of the law itself.
But before we let you go, I promise to leave you with a final puzzle to ponder on your own. We have talked extensively for the last hour about how the Constitution protects judges from the executive and the legislature. We see the massive, invisible walls built around them. But think deeply about this paradox.
Oh, this is a good one.
If the impeachment process under Article 124 is so politically rigorous and mathematically difficult that it almost never succeeds, and the judges now essentially completely control their own appointments via the collegium system, in a completely independent, closed-loop system, who truly judges the judges?
When independence becomes near absolute, what mechanism is left for every day? Practical accountability if a judge simply underperforms, delays justice for years, or acts unethically in ways that fall just short of the massive threshold of impeachable offenses.
Exactly. It is the great unresolved tension of the Indian Constitution, something to chew on before your next exam.
It is a vital, open question for the future of the Republic and the health of the justice system.
Keep questioning the structures around you, keep exploring the deep foundations of the law, and good luck with your studies. We will see you next time on The Deep Dive.